Broomfield versus Extraction Oil and Gas Inc. Good morning, folks. If you'd all be good enough to enter your appearances, beginning with the appellant.
Good morning, Your Honor. My name is Ghislaine Perez-Bruner, and I'm here with my colleagues on behalf of Extraction Oil and Gas.
Ben Cohen, also for extraction.
Good morning.
And Your Honor, Colin Deal, also for extraction.
Thank you. Colleagues, I should say.
Yes, good morning, Your Honor. Josh Marks, with the firm of Broomfield, Greenleaf and Rashidi, outside counsel for the city and Broomfield. With me at council table is Nancy Rogers, the city attorney.
Thank you. Matters before the court for oral argument on extraction oil and gas as a fuel, the municipal ordinance prosecutions and convictions. I wish I could tell you folks that you could take your masks off, but I can't. Especially in light of the uptick of the Delta variant. The chief judge has continued the order that we all have to be masked, so it's going to be inconvenient and hot. I understand that. I would greatly appreciate if everyone used the podium and spoke loudly and clearly. One, to make sure we have a good record, and two, I'm getting old and my hearing's not that great anymore. My wife has been entreating me to go get hearing aids, and she's won. All right. I presume, Ms. Torres-Bruner, you're going to go first, correct?
Yes.
All right. Like I said, I'm giving everybody an hour. And obviously, the appellant's extraction can certainly reserve whatever time they wish to do so. And when you start speaking, I will start my timer. Okay? So, with that said, please go right ahead and proceed when you are ready, Ms. Torres-Bruner. And you can anticipate I'm going to interrupt you. Perhaps.
Good morning, Your Honor. My name is Ghislaine Torres-Bruner, and together with my colleagues, Colin Deal and Ben Cohen, that are both here today, we represent Extraction Oil and Gas. As a somewhat of a preliminary matter, at our earlier hearing in August before you, we expressed to you that we would like to divide our time. First, we're going to want to reserve rebuttal time of 20 minutes, which will be taken care of by Mr. Cohen at the end, obviously, of the day today. The remainder 40 minutes are going to be divided in 3 sections, 2 of which I will take. I will address the code-based reasons to acquit, as well as the contractual basis for to acquit, and Mr. Cohen will address the 6 constitutional reasons to acquit. We're here today because in 2017, Extraction and Broomfield entered into a deal. They entered into an operator agreement that was approved by City Council Resolution 2017-186. And how did that come about? That came about pretty clearly because in 2015, Extraction purchased a variety of interests, some from Noble Energy and some from Sovereign Operating. And it found itself with these interests, and it came before the city and said, we're going to develop our interests, and we want to make a better plan. We want to work with the city and get this operations going. And in that engagement took a span of over 2 years of engagement, including tours to the various well sites that Extraction was already operating, studies with respect to traffic, noise, air quality. The project was extensively studied on all phases of operations. And what came about was this operator agreement, and in the operator agreement, it was agreed to that a CDP would be submitted. It's a comprehensive development plan that would include a culmination of all of those studies that were used to evaluate, plus the plans, the schedules that were going to be implemented, and how long the operations would take. See, oil and gas operations are temporary in nature. They're basically construction operations, similar to building a road or a house. And so it was important for extraction to share with the city what those plans look like and what mitigation measures they were going to bring forth. So they obtained their approval for the operator agreement in 2017 and in 2018 for the CDP, for the comprehensive development plan or drilling plan. And they went to work and they started building their sites. And they actually built the interchange site first and then interchange B, and then they started development of Livingston. And what happened? And why are we here today? Because in January 2020, Broomfield enacted a new noise ordinance in their chapter 9-36, which is their noise code provision, and they alleged that it was necessary because of an emergency. And they began ticketing extraction. They claimed that it applied to extraction, even though extraction advised that they did not believe that it applied to them.
And council,
yes.
focus on that for me. Why, I want extractions rationale, why the 936-101, that's the definitional section, but why the code, the newly enacted code, cannot, as a matter of law, apply to extraction?
Thank you, Your Honor.
Sure.
The reason why is because the municipal code actually has a specific chapter, 1754, that addresses all oil and gas development. And within chapter 1754, it actually goes further in detail to provide two permitting processes for oil and gas operations. The first being a use by special review, which I would consider the bare basic building blocks of what an oil and gas development would have. It has the basic requirements, and then it also has 1754-200, which is actually an enhanced standard, which means that an operator can come in and negotiate with the city to enter into an agreement, an operator agreement that provides additional measures, some maybe that are only available to the specific operator, that would enhance. And under 1754-200, subsection 23, it actually addressed noise. But going further, 1754-200 allowed for this operator agreement, and that operator agreement was in fact entered into.
So it's not a use by special review, correct?
Exactly. It is an operator agreement. It is an MOU operator agreement under 1754-200. So it becomes that because that agreement was approved by City Council Resolution 2017-186, it becomes in essence the governing law, the regulation. That becomes the regulatory regime for oil and gas. In other words, there could be a provision out there that is different, right? But the one that's going to govern are those terms that are in the agreement. And it goes even further than just the agreement. It's those terms that are included in that comprehensive drilling plan of how things are going to function. So the agreement lays it out and it becomes the regulation. And that's why 936, chapter 936 does not apply. But assuming that, so as I mentioned before, I was going to discuss 6 reasons, right? So getting a little bit deeper into why 936 doesn't apply. If we look closely at 936, it specifically requires a use by special review. And as I mentioned, we're not a use by special review. We're approved by an operator agreement. But it goes even further to say that it has to be an industrial site that is in an I2 and I3 zoning district and without a roof. But if you look at the operator agreement in paragraph 15. There, paragraph 15 specifically says, Broomfield can bring forth a future regulation so long as it is general in nature, applying to commercial and industrial operations. Well, here, chapter 936 limits it not only to industrial, but industrial regulations in an I2 and I3 without a root. It does not touch upon commercial. And the problem with that is that there was an agreement, and there was an agreement that if it was going to be something general in nature, then perhaps it could apply, right, to extraction. But extraction position all along has been that it does not apply. And for that reason alone, I mean, there are 12 reasons, as I said before, that reverse, and you only need one, and that's one reason. But going further, with respect to the 936, 936 establishes that extraction was required to either submit a modeling study predicting that its operations would be 40 dBA or less at night, or that it was to conduct noise studies demonstrating, in other words, active operations, so noise studies during active operations, where the noise levels were under 40 dBA at night. So this is an impossible to comply with standard. And there was testimony to that effect in the trial.
And in reviewing the appellate record, that would be, you had a definitional argument, your motion to dismiss before the municipal court judge, correct?
We did.
And am I correct in my assessment that you were referring to 936-101 of the Broomfield Municipal Code subsection?
With respect to the use.
Industrial use means any industrial use that must be permitted by a use by special.
Yes, exactly. And oil and gas operations in the city and county of Broomfield do not, it's the must is the key word there. They can actually be permitted either by a use by special review or an MOU. So, but back to what I was explaining to you with respect to the impossibility argument, it was calling for a noise modeling and a noise study. As I mentioned earlier, extraction was already in current operations. The city and county knew exactly where what the noise levels were going to be because they had studied them. And in the CDP, it specifically said in the noise section that the noise regime that was going to be applied was that set forth in the operator agreement in BMP 31, which was that the noise levels would be ambient +4. So whatever the ambient levels were calculated to be in each pad pre-construction +4 dBA. So what happened? Extraction was already in the middle of operations. It was clear what ambient was because that was a study that was actually done even before the operator agreement was entered into. Why? Because the city and county of Broomfield wanted to know what kind of noise, what levels of noise would exist. And so what happened? There was two important things that are referenced into in BMP 31. One is the previous studies that were done, which were up in different operational sites of Weld County, in the Triple Creek site and certain other sites that City and County Broomfield went and listened to hydraulic fracturing, drilling, hydraulic fracturing, and of course production, once the wells were producing. And they evaluated what those noise levels would look like at night. On top of that, True Horizons was hired and approved by the city and hired, and they went out to the Livingston site that is at issue in this case. And they evaluated what those noise levels would be. And it was clear that the average ambient across the 7 days was going to be 61. So it was known that it was 61. But if you were to break that down even further, it was known that noise level at night was going to be 46. So the extraction and the city and county of Broomfield came up with a way to determine what those noise levels were, what those averages were going to be. And they set their noise regime that is illustrated in BMP 31, and it was supposed to be ambient +4. So at no time, I mean, it's undisputed before the case before the municipal court, but extraction was in compliance with with the ambient +4. It's undisputed. So, where do we find ourselves? We find ourselves in a situation where they conducted the noise modeling in advance. At this point, they're already in operations. It's somewhat silly, I guess, to go back and have to run a noise model, on a site that's already operating, but we had actual data. So it was an impossible standard as testified to by the witnesses in that lower, before the municipal court. So another point that I would like to turn to are the contractual reasons to acquit. Those were the two reasons that we had illustrated for acquittal with respect to the code, but with the contract, with respect to the contractual reasons, we also need to take a look at the future regulations provision. The city would like you to believe that the city's police powers gives it unfettered discretion, free reign, carte blanche, whatever way you want to look at it, to unilaterally alter or nullify the contractual terms, because they supposedly have this ability, the city has this ability to enact regulations. Well, that is flat wrong. The city definitely has the ability to exercise its police powers. Those were never traded in the operator agreement. The operator agreement clearly noted that extraction would, in a situation where the city and county of Broomfield felt that there was a reason to enact a new generation that was general in nature and applicable to all commercial and industrial operations, that they could bring forth their, that it could be imposed before the city. There was no situation that has been demonstrated that was outside the operator agreement. In other words, there was no crisis or emergency that was not contemplated. Noise was contemplated. It's not only contemplated in 1754, which is the narrower law of noise, but it was contemplated in the operator agreement in 1851. So that argument fails.
Well, but let me ask you this, Council. I mean, certainly as a homeowner municipality, city and county of Broomfield most definitely has police powers, and they can use that to protect the health, safety, welfare of their citizenry, correct?
That is correct. However, when they enter into a contract, those and there's contemplated terms, those contracts cannot be overwritten.
But the city can't contract away its police powers, can it?
But it never did. It did not contract away its police power. It was specific in articulating how the police powers would be, could actually be exercised. And it was exercising it in situations where it was general in nature and applicable to commercial and industrial operations. And there's a reason why. Because it was contemplated in the agreement that development would begin. If you look at paragraph 12 of the operator agreement, it actually talks about the fact that there were going to be a series of approvals that were going to be given. And in a situation where you had a series of approvals given, and as we had here, not only were those approvals given, but operations were going on, that extraction could ask for a waiver if in fact it was a valid future regulation as it could be applied to extraction. In other words, what would be a true regulation that could apply to extraction was one that was general in nature, applicable to commercial and industrial operations. So in a situation like that, what would happen would be that if in fact it was something that said, that it was applicable to commercial and industrial operations, then extraction would have to look at its plans, which were already approved and were in progress, and they could seek a waiver or a variance. And so that is how and you have to consider paragraph 15 and 12 in harmony to that effect. Because of the fact that we have two provisions and we can't in any way invalidate one of the provisions of the agreement without reading it in harmony with the other. So that's how you read them together in a situation where we had a valid future regulation as applied to extraction, then extraction had this, ability. But this wasn't a valid future regulation. All along, extraction has said it doesn't apply to us because it's not general in nature. Your Honor, I am out of my first 20 minutes. If I could allow Mr. Cohen to address the constitutional arguments at this time, but I'm happy to answer any questions that's applicable to my question.
I guess my question is, am I correct in my review of the record that the predecessor and interest sovereign, that particular operator agreement did indeed contain similar language to paragraph 15. It specifically contemplated the city's ability to enact a future regulation. The verbiage was changed a little bit, but all along throughout the relationship between these parties, whether under the sovereign agreement or the amended and restated, the city's always contractually, at least it was put in there, retained the ability and the authority to enact a future regulation.
But it wasn't unfettered because there was a limitation in paragraph 12. And actually, interestingly, in sovereign, in that agreement, the language of the future regulation was very narrow. It was actually specific to oil and gas. It was targeting oil and gas that the city could then bring forth, but it still was general in nature in that, as applied to oil and gas, but didn't undo the rights that the operator sovereign had. And actually, this court, Judge Melanakis, said that extraction had vested rights. But I'd like to allow Mr. Cohen to address those issues.
I just wanted to talk a little bit, I'm sorry.
Oh, go ahead.
I understand what Judge Melanakis said. I obviously read his prior order. But with all due respect, if someone's going to suggest to me that I'm bound by what Judge Melanakis did, a co-equal judicial body under the law of the case doctrine, I'm simply not bound by it. Do you agree or disagree?
I agree that you can make your evaluation in accordance with what we place fit. I apologize.
No, that's fine.
That was, and I'll let Mr. Cohen finish on that.
Okay.
I want to think about it.
Perfect.
Thank you, Your Honor. I'll start by picking up there, even though I'm here to address the constitutional issues, and I'll be back and clean up the rebuttal. Your Honor is correct. We did in our briefing make specific arguments regarding the prior sovereign order. It had a future regulation provision. Broomfield enacted what was, back in Sovereign's day, a potentially fatal future regulation. Broomfield enacted a hydraulic fracturing moratorium, and Judge Melanakis said no. Sovereign's rights are vested; they cannot be impaired by subsequent legislation. All our arguments regarding the prior sovereign order, and I absolutely agree, it's not law of the case here. There is an element of issue preclusion in the sense that this exact issue was looked at and decided, and if nothing else, it's highly apposite because it's the exact same situation, the exact same contractual rights or the rights that extraction bought here. So Judge Melanakis's specific findings and determinations about vested rights do apply here. And by the way, Your Honor, that's not disputed. Broomfield does not dispute the fact that extraction rights are vested. So extraction has vested rights to develop oil and gas, to purchase them from Sovereign and Noble, and then after entering into this operator agreement in 2017, extraction did the same kind of justifiable reliance based on the operator agreement. It invested millions of dollars in a pipeline system and constructing its facilities with sound walls and all kinds of mitigation equipment so that it would be able to operate per the party's deal in BMP 31 of never generating more than ambient +4 decibels, which at this particular site is 65 decibels. And extraction has done that. It hasn't been easy. Extraction has had to implement state-of-the-art sound mitigation. But it did it at substantial cost, and it has kept its noise levels down to the levels that the parties agreed upon. Here's 65 at Livingston, which is 10 decibels lower than the level that would have applied under the sovereign agreement, and that generally applies per the, in effect at the time, COGCC Rule 802. That 10 decibel differential is a huge win for Broomfield. Well, we acknowledge, we're here because Broomfield residents complain about extractions noise. It could have literally been twice as loud as it was and still have complied with applicable state law and the applicable sovereign operating agreement. This is much quieter than it would have otherwise been. So,
But the General Assembly in 2019, Senate Bill 1981 further gave extraction additional regulatory authority, did it not?
that is right. No, it gave Broomfield.
I'm sorry,
additional authority.
Broomfield.
That's right, but the General Assembly in SB 181 certainly did not say, and all operator agreements, all deals between operators and cities are off. And the General Assembly didn't say that. It couldn't have said that because that would have been a classic law that impairs the obligation of contracts, which is what I'm here to talk about, the constitutional reasons. Appreciating that there is the doctrine of constitutional avoidance. The court might choose not to go here since there are.
Can you tell me, and I'm assuming it's Ms. Torres-Brunner's, from her perspective, I don't even have to reach these constitutional arguments.
You don't, Your Honor, but we present them because they're good constitutional arguments. You can reverse the convictions on these bases as well as the code-based reasons or the contract-based reasons. And even though we acknowledge the doctrine of constitutional avoidance, as we've said in our briefs, Broomfield needs to hear this from the court. If extraction is going to be able to finish its work and finish up and do its job quietly and cleanly and safely and then be gone. Extraction isn't setting up permanently here. These are all temporary facilities. Once extraction is done, developing the oil and gas minerals that it is here to do it, it'll shut down and be gone. All of the noise nuisance or any other nuisances are temporary in nature. And they're substantially reduced from what they would have otherwise been, and they are within the parties agreed upon parameters.
I don't know if you wanted to use the word nuisance.
I apologize for nuisance, but nuisance is something that Broomfield has faced. And we'll just speak in terms of loudness and volume and noise. But getting back to the constitutional issues, Your Honor, vested rights. Colorado Constitution, Article 2, Section 11, it's titled ex post facto laws. There's no ex post facto law nor law impairing the obligation of contracts or retrospective in operation shall be passed by the General Assembly. That applies as well to local governments for PW investments in the city of Westminster. Now, the Colorado Supreme Court has adopted a definition of a retrospective law. I actually researched it back. It turns out that it was first articulated in an 1814 case by Justice Story. The definition is, a law is retroactive, or in Colorado terminology, retrospective, if it, quote, takes away or impairs vested rights acquired under existing laws. That's our situation exactly. And that is why extraction here does have a valid claim under the ex post facto law prohibition. Most cases addressing retrospectivity in ex post facto are usually an argument about whether the property rights at issue are vested. You see, cases about prisoners claiming their time credits are vested property rights, and no, they're not.
So that's step one of the analysis.
That's step one, but of that, there is no dispute here that extraction rights are vested. So the question is quite simply, does Broomfield's 2020 noise ordinance, quote, take away or impair vested rights acquired under existing laws? Yes, it most certainly does. Under the existing laws in 2017, extraction could have operated at up to 75 decibels prior to the entry of the operating agreement. it made a deal with Broomfield, which was a win-win situation. It lowered the noise limit down to ambient +4, which is 65 here, but that was a level that extraction could still operate. And extraction did. The municipal court below, in the course of this trial, expressly found that extraction at all times complied with the agreed upon noise limits of ambient +4. Now, Broomfield's primary argument, only argument really, against application of ex post facto and vested rights and retrospective legislation is that this constitutional law yields to Broomfield's police power. We disagree, Your Honor. We start from the premise that this is Colorado, and in Colorado, municipalities, any government entity is bound by its contracts. The Supreme Court abrogated sovereign immunity in the 1971 Edmonds case. Maybe in other states or the federal government, they can be bound by contracts if they so choose to be. But here in Colorado, a city makes a contract, the city has to honor the contract. And the most apposite case expounding upon that is the Colawyo coal case, in which the Colorado Court of Appeals said to Colorado Springs, look, you entered into a long-term contract with this coal supplier. You got police powers, but your police powers are not a get out of any contract free card. The Colorado Court of Appeals there held that Colorado Springs was bound by its contractual deal. In the course of reviewing the police power, it noted that, okay, there might be emergency situations where a municipality, a government has got to do certain things. And yeah, maybe in that situation, the police power could trump, but there's no emergency here. As Ms. Torres-Bruner explained, Broomfield, before entering into this operating agreement, extensively studied operational noise at oil and gas sites, including touring extractions of the facilities, conducting ambient noise studies at all of the sites. It knew exactly what the levels were, the ambient noise levels were. It knew what extraction's noise levels would be when in operation, and it agreed to ambient +4. So this is not a kind of emergency situation. Now, to look further at the additional retrospectivity case law, you'll see in the briefs, extraction has got its two preferred cases. Broomfield has its two preferred cases. We submit that ours are far more apposite. So if the court is going to look at case law for guidance, which pretty much have to do here, extractions cases are the ones that the court should be following. The Eason case is far and away the most apposite. That was the one where Mr. Eason wants to establish the self-storage business in Boulder using semi-trailers. He gets a permit from Boulder County. He pays for the permit. He then, armed with this permit that allows him to bring 100 semi-trailers on the property for his business. He buys the trailers and spends a lot of money in justifiable and reasonable reliance. And then a little bit later, Boulder County basically says to him, well, we changed our mind. No more semi-trailers, get them off the property. And Eason sues. And both the district court and the Court of Appeals saying no. Eason's rights are vested rights because he reasonably relied on his permit. Boulder County just can't change its mind and enact a different law. What's more, Eason not only successfully obtained that ruling that the Boulder County Commissioner's order telling him to take his trailers and leave was unconstitutional. He sued. He sued Boulder County under Section 1983 for violation of his constitutional rights, and he won. We note in passing that extraction has asserted similar Section 1983 claims against Broomfield, not in this case, and not in this court, but rather in federal court. But think about Eason. Our other apposite case, Your Honor, is the Goldenrod development case. It's an older Court of Appeals case where a developer, relying on its approvals and permits, builds a whole infrastructure for subdivision, and then the county changes those rules. The Court of Appeals says no. You can't just change things. You have a vested right. By comparison, the cases that Broomfield was offering with the car, that's the bail bondsman case, where the bail bondsman, even though they got to renew annually, we've got a vested right to always have our bail bondsman licenses renewed. No, you don't. You got to renew them annually, and things change. The DeWitt case is even less apposite, where the divorcee claims, I was a beneficiary under my ex-husband, the court nods indicating that it knows these cases. So you look at the case law, the opposite case law clearly favors extraction here. That's the vested rights retrospectivity analysis in a nutshell. The noise ordinance is subsequent legislation that impairs extraction vested rights. It's unconstitutionally retrospective. It's also ex post facto, Your Honor, for the simple reason that it's criminal law. It imposes criminal penalties. And you don't often see actual ex post facto cases. Like retrospectivity, it's usually a question over whether rights are in fact vested. But the Colorado Supreme Court has defined ex post facto as when a statute violates the constitutional prohibition of impairing vested rights acquired under existing laws and it's criminal, then it is ex post facto. You can imagine, no, we don't have any cases on this, probably because legislative bodies don't enact such plainly ex post facto laws. But imagine if in the Eason case, that's the most famous case, if what Boulder had done was not simply order Eason to remove his trailers, but had enacted an ordinance that says it shall henceforth be illegal to run a self-storage business using semi-trailers, subject to criminal penalties, and then cited Eason and prosecuted. That would have been a classic ex post facto law. And that is what Broomfield has done here with this noise ordinance as to extraction. I'd like to address special legislation so that we can save some time for rebuttal. Colorado Constitution, Article 525, is a special legislation provision. It serves purposes similar to the Federal Equal Protection Clause, but it is much more specific and frankly much more powerful. It says, quote, where a general law can be made applicable, no special law shall be enacted. That's pretty strong language. The Colorado Supreme Court has applied that in cases like the Bosch case from about a century ago. Denver decides to impose Sunday blue laws that require businesses to close them only on clothing shops and pawn shops. Special legislation. It should apply even-handedly to all businesses. Well, the subsequent case law, the case that we like the definition, is that legislation that is, quote, unquestionably conceived, cut, and tailored for a particular situation is unconstitutional special legislation. That's the case that we offer. And if ever there were an example of that, it's here. We go through all of the aspects of special legislation, starting from the city council's discussion of how now we believe it. The city council may well have believed, and the city manager may well have believed that Broomfield has got new powers with SB 181, not appreciating that it can't operate retrospectively. But Broomfield thought, armed with SB 181, we can shut extraction down. The city manager essentially said so. That's what we're working on. We're going to penetrate this contract. Broomfield tried several shutdown strategies, using the wrong drilling, using the wrong evidence. The court will recall the public emergency health order, where we were here a little over a year ago, where stress and anxiety. This noise ordinance, we said that Broomfield chose noise as its best vehicle. The noise ordinance repeatedly calls out extraction by name in the preamble. And the definition. It doesn't apply. We've acknowledged that the future regulation paragraph would enable Broomfield to use its police power to enact a neutral, generally applicable night noise ordinance that applies to all commercial and industrial operations. But this noise ordinance applies only to certain defined industrial operations that don't have roofs. Without a roof, really says it all in terms of special legislation.
Mr. Cohen, I
Yes.
know that Ms. Bruno was discussing this, but I want to get back to the definition contained in 936.019.
Sure.
Subsection F. Industrial use means any industrial use that must be permitted as used by special review. And she's already, and I agree, that's not the situation here. And that was one of the bases under which you moved to dismiss the municipal prosecutions. Is there any other ambiguity you believe in subsection, that definitional section?
in the definitional section, well, first of all, and this was well developed at trial, Your Honor, correct, extractions, operations are not permitted by a use by special review permit. They're permitted, authorized pursuant to an operating. Then the definitional section says, quote, industrial use includes, and it provides a long list of certain types of plants and manufacturing and so on and so forth, and raw animal and vegetable products, distribution of. So some strange definitions, but towards the end, it says oil and gas operations. And of course, extractions operations are oil and gas operations. We submit, Your Honor, that given the linguistic structure, the language that Broomfield chose for this definition, when you define a category, which is what this definition does, industrial use means those industrial uses that must be permitted as a USR. And then you say industrial use includes, and you'll give a big list. That list are all examples of the defined category. So the reference to oil and gas operations is not a reference to all oil and gas operations. It is, by definition, those oil and gas operations that must be permitted pursuant to a use by special review, not extraction. So Broomfield's definition, and this is important because we know that Broomfield intended for this noise ordinance to apply to extraction. It says so right in the preamble. And in the city council meetings adopting it, it's all talk about this is going to apply to extraction. So yes, Broomfield intended for this to apply to extraction, but Broomfield chose language that actually excludes extraction. It's quite ironic. But this is a criminal ordinance, Your Honor, and Broomfield, there is no, come on, you get what we meant. Doctrine in criminal ordinance, quite the contrary. Criminal ordinances, you've got to have language that is going to be viewed objectively and must use precise language to put people on notice of whether they come within the suite. Broomfield may well have intended for this ordinance to apply to extraction, but by its plain language, it does not. If the definition had said, in addition to the category, all industrial uses that must be permitted, industrial use shall also include all oil and gas operations. That would be language that would bring extraction in. But it doesn't do that. It simply defines permitted uses or defines industrial use as those uses that must be permitted, gives a list that includes oil and gas, hence those oil and gas operations that must be permitted, not extraction. And extraction, ironically, is not part of the definition, which is one of our 12 ordinances. At this point, Your Honor, we've got about 20 minutes left, and we're going to reserve that for rebuttal. Let Mr. Marks.
My stopwatch said you reserved 19 minutes, 36 seconds.
Exactly.
Fair enough. All right, Mr. Marks, go right ahead, sir.
Well, Your Honor, Josh Marks on behalf of the city of Broomfield, as you know, we're the appellee in this case. I'm going to suggest to you a different structure for looking at this case. One of the things I try to do as an appellee is put myself in your shoes and try to understand what might be the most efficient way to look at an appeal. And I think the first issue, important issue in this case, really is looking at it as, did Broomfield enact this as part of its police powers? Did they enact, let's call it the emergency noise ordinance, and more specifically, section 9-36-010 at SEC, the changes to that. resulted in OAO, which is the noise provision and the requirement to provide a study, which, which extraction undisputedly did not in this case. That's, this case, and that's the odd thing about this appeal, Your Honor. This isn't about proof. Extraction doesn't dispute the conduct that led to the citations and convictions in this case. Absolutely no dispute that absent their arguments about the definition of industrial use.
Well, that's what I kind of would like you to talk to me about, because I read industrial use means any industrial use that must be permitted by use by special review.
Right.
That's your client's definition. And if that definition doesn't apply to extraction.
But there's a second sentence, and you can't skip over that second sentence. And that's why, and that's what the trial court determined here, that the second sentence is not superfluous. It's not illustrated. It's different. It specifically calls out specific uses that are captured as industrial uses. There's two different, and Your Honor, you have to understand the difference between the two. The first sentence talks about the kinds of uses that can be a use by special review under the zoning. And Your Honor, those uses can change over time, and they will change over time. Broomfield changes permitted uses and excluded uses in its zoning over time. So the first sentence captures those uses that over time will change in the I2 and I3 zone. The second sentence, however, is more categorical. And so the city and county decided that we're not going to make this statute and the application of this statute dependent upon zoning changes over time. We're also going to call out specific uses that are indisputably and categorically covered by the definition of industrial use. And that includes the development of or operation of oil wells or gas wells, which undisputedly apply here. And the trial court understood that there's a couple ways to read this. And the trial court properly then used rules of statutory construction to adopt the meaning, adopt the interpretation that I just described for you. There's two different sections of the definition. So
Are you conceding that it's reasonably susceptible to multiple interpretations?
I think it's susceptible to interpretations. I'm not so sure reasonably so, but I think the court had to resort to statutory construction aids to harmonize to come to its conclusion.
But if that is indeed what the lower court did, with all due respect, I mean, we're talking about ultimately a criminal prosecution, and if there's some type of ambiguity, indeed, I think the lower court kind of acknowledged that. Doesn't the rule of lenity dictate it be construed in favor of extraction?
No, I don't think so, Your Honor. I think in this case, because as the trial court concluded that the second sentence clarifies the definition. And so I don't think there's the rule of lenity has to apply here. The court ultimately determined that industrial use, the definition captured extraction. Plus, Your Honor, and as extraction just admitted to you, it was crystal clear that when this ordinance was enacted, that extraction's operations and the noise that it was creating was the impetus for this police power piece of legislation. So there's no need to invoke a rule of lenity here. It was pretty crystal clear what the city was trying to capture here. It was situations like the scenario that extraction presented. It was an industrial use in a non-industrial zone district, which incidentally is a gap in the city's noise regulations that it was trying to fix. And what this ordinance did was put those kinds of uses on par with the noise restrictions in the industrial zone area. So it put them, so it evened the playing field in this area. And of course, Your Honor, that's captured by the legislative history of the ordinance.
Meaning what?
The ordinance, if you look, meaning the whereas clause in the ordinance itself, talks about how there's this kind of gap and we're bringing uses that are industrial uses that are in non-industrial zoned areas in line with the same noise requirements as industrial uses in industrial areas.
Well, let's look at this a little more closely with all due respect, counsel. Well, section F starts out with industrial use means. Any industrial use that must be permitted as a use by special review in an I2 or I3 zone district, period. Next sentence. Industrial use includes. It doesn't say means. So it doesn't, that's just an illustration, isn't it?
No, it doesn't. And the problem with that is it violates the rule of statutory construction. But by reading it that way, you're making the second section just a total nullity, because if all it's doing is just describing what's already described in paragraph 1, section 2, sentence 2 is meaningless. And we know as a rule of statutory construction that ordinances have to be read in a way that give meaning to all of its words, not just some of its words. And that's the problem with by saying, well,
why didn't the city and county of Broomfield write that second sentence? Industrial use also means.
Well,
I know
it might have been. I wasn't there, and it might have been clear, but that's not the test, right? The test is, in this case, it's an interpretation, and that is it good enough? And the city and county of Broomfield submits it is.
And what's the impact of the many comments used suggesting, well, no, we're specifically saying this includes extraction.
Well, no,
I'm not talking about this definition.
Oh, okay.
Is it in the record?
yeah.
In the record that the city unabashedly said, oh yeah, we want to make it clear, this applies to extraction.
Correct. I mean,
Doesn't that kind of smack of special legislation?
no, Your Honor. Let's go back.
Okay.
Now, I want to jump back. Special legislation under the Colorado Constitution, that's what we're talking about. Article 5, section 32. Article 5, section 25. Let's talk about the test for that, which of course isn't mentioned by extraction. The legal test is whether the law is so logically and factually restricted that it could only apply to a person or a group or a particular group.
Okay.
But where a statute could apply to others, it has broader applicability. It's not special legislation. Let me give you an example. And this is all discussed in the Teta versus Corrigan case that we cited in our brief. And interestingly enough, it cites to another case called People versus Conister, which was a case, criminal case, that involved special legislation. One of the very few cases where the Colorado courts have found special legislation with this provision to have been violated. And in that case, it's kind of interesting to look at the facts of that case, but that case involved, and Your Honor, don't know if you're on the bench at this time, but there was a time in which Colorado's death penalty sentencing phase was declared unconstitutional. Well, there was a Supreme Court case that came down that didn't allow for 3-judge panels.
That was before I was appointed. That was prior to 2010.
Yeah, okay, but it wasn't too far in advance of that, I believe. And what happened in the aftermath of that is that the legislature called back into session and created this special piece of legislation to deal with what to do with people who are already convicted but not yet sentenced. And that only applied to 2 people. And the legislation said, as of this date, if you're in that position, this law applies to you. And the Colorado Supreme Court looked at it and said, the only way that that thing could be applied is to 2 people in the case. And the interesting thing is, Canister also made the comment that it's not special legislation if it broadly applies to others, even if the legislative body had in mind a specific entity in the legislation. And that's at page 384. And that's what Extraction is complaining about. That Broomfield had it in mind. It was the impetus for this police power legislation. But when you look at the text of the legislation, as you pointed out to me, as Extraction concedes, it applies to a wide variety of uses, not oil and gas operations only. And because of that, because it has a potential broader use, it absolutely is not violative of Article 5, Section 25. So that's why it's not special legislation. Okay. And nor is it unreasonable, in a police power sense, Your Honor, because the legislatures are often reactive to situations. And are, that's what the police power is for, to react to situations that arise to help address, health, safety, and welfare problems. And here, I think it's undisputed that Extraction had noise levels that were creating complaints and disturbing people's lives. And the city council tried to enact a provision to help address that and future issues, because the legislation, this goes back to the special legislation provision. This would equally apply to legal non-conforming industrial uses throughout the city. In other words, industrial uses that either pre-exist the zoning or were appropriate under zoning at one time and later changed out of industrial zones. So there's the potential for its application into the future. And so that's why it's not special legislation. And that's why, for the same reason, let me get back to, this is a valid police power regulation. And that's incredibly significant, because the one case that hasn't been discussed with you, which I think is probably the most important case dealing with this issue, is Van Sickle v. Boyd. We talk about it in our brief, but Van Sickle, the Supreme Court announced the general rule with respect to retrospective law that a valid police power regulation that is subsequently enacted is not immunized by a prior permitted or vested right. In other words, it can be applied to an existing permit or an existing approval. And Extraction has turned that case on its head when it argues to you that Broomfield is limited in applying, the noise ordinance by virtue of its operator agreement, by virtue of its contract, because the rule about, you can't contract away the police powers. It's the flip side of the principle I just announced to you, that governments, when they enact police power regulations, compliant to existing approvals and existing permits. Van Sickle is that case, because, and I don't know if you've read it, but it's not exactly, doesn't have all the factual similarities, but that was a case where someone got relied upon Boulder's approval, city of Boulder's approval to do remodeling and got a building permit. Relied upon that building permit, did the remodeling, and Boulder, through its inspection process, tagged it for being out of compliance with changes in safety and fire code law. And Van Sickle tried to argue that this was improper retrospective legislation because, that they're going after him for, for constructing based on a prior building permit, which incorporated prior building code. And the Supreme Court said, went through the retrospective legislation analysis and made the categorical rule that we're relying upon here, that changes, that enactments under the police power are not constrained by an existing approval. Extraction, and bring that to extraction, extraction's operator agreement is effectively the same thing as Mr. Van Sickle's, building permit approvals that he relied upon too. There's just no distinction legally between these two cases. And so that's why, well, once you get there, it disposes of all of extraction's arguments that its operator agreement controls and constrains the city's ability to enforce Section 9-36. It just simply defeats it. So you never have to reach what the operator agreement, Section 15, the future regulation says or doesn't say. You don't have to reach whether Section 12, which deals with variances and approval, says. So it takes care of all that. So after you get through that, Your Honor, what's left? And what's left is the special legislation challenge, which I just went through the analysis for you. And as I mentioned, there are other constitutional claims. There's the retrospective legislation challenge. I suppose, there is an argument, they made the argument that this isn't valid use of the police power. But if you go through the proper analysis for what's a valid use of the police power, it is effectively a rational basis review, which means, in Your Honor, I don't think I think the best case that talks about it is not cited in our brief, and I apologize for that, but it's called Town of Dillon versus Yacht Club Condominiums. And that's the Colorado Supreme Court's, I think, last big analysis on the police power, how to do this analysis. And again, they say it's a rational basis review. All we're looking at is whether your objective, whether there's a rational relationship between what you're doing and a legitimate governmental objective here. And so this piece of legislation undoubtedly satisfies that analysis. Nobody argues that the regulation of noise is, it is an illegitimate governmental objective, right? Broomfield's done it in other aspects of its code. So the real question is, is the law that was enacted here, the extra amendment, is it rationally related to the regulation of noise? And that's Your Honor, that's such an easy conclusion to reach here, because here, as I described, the changes and the amendments that we're talking about, the reenactment or a new enactment for industrial uses, made those uses comply with the noise standard, right? Which is the quintessential way to regulate noise by anybody is by setting the decibel level and saying, hey, you gotta comply with that. And on top of that, what Broomfield did was ask that someone who is an industrial operator, fits under the definition, come up with a noise study to help it quantify whether, whether they were in compliance, out of compliance, or could form the basis of the next step, which would be a variance in the event that someone, couldn't come into compliance. So here, the thing that extraction was charged with, is intimately and rationally related, which is the failure to provide the noise study. And hence the noise study requirement is rationally related to the regulation of noise. So we have a legitimate and reasonable use of the police power here. So that finishes the analysis of all constitutional changes that are being brought here. So I think then if I was writing this, I think the next level that I would be reaching is the non-constitutional arguments. And you and I already talked about the definitional challenge that's been made by extraction. Extraction has also brought up that section 17-54 of the city code is the one that they should be charged with, not 9-36. And Your Honor, as our brief talks about, that's an argument that wasn't raised below. A related argument was raised below, but that particular contention was not raised. When I went back through the motion for judgment of acquittal, which raises an awful lot of argument, the way extraction got into this was they tried to argue that the specific section of the operator agreement required the city to, if it was going to enforce anything against them, to only enforce it under section 17-54. They did not make the argument that there's some legal hierarchy that requires Broomfield as the prosecutor to have selected a more specific over a more general statute to prosecute them under, which is the argument they're making now in their brief. It's a different argument. So that they made a contractual argument more than a prosecutorial discretion argument below. And so I think that argument's waived. But even if you want to address the merits, the argument's in error, because here we're not talking about a specific over a general law in which the prosecution has decided to prosecute under a general law. We're talking two very different provisions. 17-54 is the oil and gas regulations, the land use regulations of the city in the oil and gas operation. And it is the provisions for violation of that are largely civil. So if someone violates land use regulations, they can get their land use approval revoked, or they could get there's a provision for the city to go into court and get those those improper uses enjoined. But I'll also tell you that the provision also could allow for a penalty if violated. Well, contrast that with the noise provision of section 9-36. It is criminal in nature, because the only thing it allows for is a fine and jail time, which jail time doesn't apply here. But so the only thing here is a fine. So this isn't a matter of selecting a more general criminal law over a more specific. That the paradigm just doesn't fit here. And so that argument just doesn't hold water. So then the last argument, I believe, that's left is, and Bruner alluded to this, impossibility defense that was raised at trial. And the trial judge here properly rejected the impossibility of that. And he did so for, and we pointed this out in a number of ways, but the first, let me tell you all the reasons why. The first reason is that, we have to remember, this was Extraction's affirmative defense, their burden to prove it. And all the elements of impossibility. And there's many different ways in which.
Can I just ask something? You said it's their burden to prove it. It's criminal prosecution. It's an affirmative defense. It's the government's burden to disprove it.
Yeah, right.
Okay.
Yeah. But they had to identify and make some prima facie showing that it's applicable before that burden, right? Before that burden shift. And that's what they didn't do in this case, is they had to at least demonstrate why it was impossible to comply with the Broomfield law. And then Broomfield could then rebut it, but they didn't satisfy their prima facie burden because to show that this law was impossible to comply with, you got to remember that the section 9-36-080 gives people options in terms of how to comply with the provision. The provision allows, for example, provision allows them, says you got to stay below a certain dBA level, 40 dBA between these certain hours. So it gives someone who's an industrial user the option to curtail their operation at night to get below that level. The testimony before that trial on that was one of their own witness, when asked about that, said that it would just take them longer to finish out their operations if they did it that way. He made a vague reference to safety. He never articulated what that would be, but instead spent the majority of his answer talking about how they had a deadline to get out and this would just take them longer. And that's at page 267 of the day 2 transcript, lines 15 to 25. That in and of itself gave the trial judge ample evidence to demonstrate that there was an option available to comply with this law by extraction. It wasn't impossible to comply, irrespective of the noise study issue. The next, however, what's being argued to you is that providing a noise study demonstrating that their nighttime operations would be less than 40 dBA would be impossible because ambient noise measurements in this area would be, in excess of 40. Now, mind you, this was those studies that were relied upon by extraction were never produced in the trial, and the court made a mention of it because he said no studies have ever been provided to me in this case. And there's a couple problems with even the testimony just talking about this study. The testimony about the studies was about ambient and not about noise that is generated by the operation itself. And the noise ordinance section 9-36-080 all talks about that the 40 dBA level is designed to measure noise from the operation itself, not ambient temperature. And I know extraction's big issue is, well, how can you possibly measure that in the case? But the point being is that there's also, the noise ordinance also mentions, in addition, you have two ways to provide a noise study. One is an actual study showing actual noise level. The other one is a modeling study. And they never address how a modeling study could not isolate noise from their operation, when in fact we know it does. And they never address that. They never They never ruled that out of their testimony. They couldn't provide a noise model study showing, taking out the ambient noise and just addressing what was required under the statute. And that's what got to the court's ruling. I've never gotten any studies of that. And then in addition, the cross-examination, even though they talked about a study, Extraction admitted it was not the kind of study that was required by the city. Because the study had to show, when they did the modeling study, it had to be at the zone district boundary, not right at the operation itself, which makes a difference because noise dissipates it as you get away from the operation. And Extraction testified that their initial modeling studies were measuring noise closer to, or their actual studies were measuring noise right at the well site and not at the zone district boundary. And that's important because they didn't rule out the possibility that they could do these kinds of studies sufficient to satisfy the ordinance. That's why the impossibility defense failed.
So essentially, I think what you're saying is, talking about this impossibility defense is that they certainly have the option not to operate the rig at night, right?
Well, they didn't say they couldn't, right? Yeah, they do have that option.
And if indeed they have that option and they can create whatever noise within certain parameters during the day, how's their contract?
Well, that's kind of begs the question. Yeah, I mean, well, as I set forth, I don't think their contract is impaired at all by the application of the ordinance in any way, shape, or form, because the law allows that's not an unconstitutional impairment or retrospective, it's not a retrospective application of the law.
It's not a taking away of something substantive due process right, it's just curtailing the exercise of that right.
Correct. Just one aspect. It's not saying you can't drill, you can't get oil out of the ground. You just have to do it within these noise limits. And of course, substantive due process is not, that's not something that was specifically raised here. It's been raised in other litigation, but not as a.
I mean, kind of naturally embedding in some notion of contract, this notion of substantive due process. It's a property right. That's the point.
It could be. But again, as you mentioned the contract, the operator agreements all the way through contemplated Broomfield's ability to enact some future regulations, which of course is their common law right as well. And those contracts, even if they were more limited than common law right, there's an element in the doctrine of the law that says when you contract with a public entity, you do so with you're presumed to know the law that surrounds contracting with a public entity. So if contracting with a public entity would effectively contract over your police powers, and the public entity says, that's what the contract, that's what you're doing by virtue of this contract. It's not an unfair thing to do.
I mean, that's why paragraph 15 was included. It's fail-safe for the government, right?
It is one acknowledgement of the government's powers. Yes, but I guess what I'm telling you is the government's police powers is even broader. It didn't have to be limited by things of general applicability to commercial or industrial operations. Under the wording, their police power ability is only limited by the constitutional provision that says you have to enact reasonable police power regulations. So every contract is always subject to that. And that's where the Colorado case comes into play. It doesn't limit that aspect of the law. The Colorado case was a different kind of contract. It was a proprietary contract. It wasn't a police power regulation. And that's why Extraction cited law to you on Eason Easton case doesn't involve a police power regulation. It was a zoning official changing his mind. So Easton never implicates the Van Sickle doctrine. Same thing with the Goldenrod case. The Goldenrod case that they cite to has, I think, huge problems. First of all, it's a 1979 case. Van Sickle comes along after Goldenrod and announces a very different rule. If you read Goldenrod broadly, but Goldenrod was, again, the public entity just, in that case, I don't think had any subdivision regulations. Developer goes in and just starts providing improved subdivision improvements and 2 subdivisions. In the midst of it, this was Delta County enacted subdivision regulations that said, well, now you gotta comply with them. It's not the same kind of police power regulation that's involved here, where we're talking about health, safety, and specific health, safety, and welfare provision. So I think Goldenrod is distinguishable on that basis. And had they wanted to have Goldenrod, I mean, the interesting thing is when you read that case, the analysis is like 2 sentences long. You can't divine anything from it. They talk about generally land use laws or perspective, and then they launch into another observation about takings law, and then they reach their conclusion. And so, I mean, it's just flawed in so many ways that I don't think it has any applicability here. So Van Sickle does, he gets rid of, a lot of the arguments that are being made here. And as I mentioned to you previously, I think, all the other offenses here just don't hold up when you look at them through the proper lens of the standards you have to apply under the law and the facts of the case. There is, Your Honor, there's one thing I didn't get, and that's the issue preclusion claim that's being made with respect to, Judge Melanakis' prior order. We've talked about this in our briefs. If you don't have any questions about that, I mean, we clearly think there's no identity of issues here. It's so different in terms of the underlying agreement. You talk about the moratorium versus the noise regulation and the police powers.
I'm not particularly persuaded.
Okay, then I'm not going to waste time on it.
With all due respect, Mr. Sparks.
The only thing I will mention though is it's just more of, I think, an issue of precision more than anything else. The constitutional claim under Article 2, Section 11 can only be really analyzed as an ex post facto law, under ex post facto clause. Because if you read the People v. District Court, it's one of the citations we've had in our brief. Supreme Court clarifies that for criminal statutes, the ex post facto is the analytical tool under that section, not retrospective legislation under Article 2, Section 11. But I believe some of the same concepts lend themselves to the ex post facto analysis. The one thing I will mention about ex post facto, though, the trial court was correct in rejecting this as an ex post facto challenge, because while there is some relation, I mean, I'm going to say the facts that and the conduct that extraction is accused of here and convicted of here is not conduct that they engaged in before the enactment of the statute. It's all conduct that happened after the enactment of the statute. And the facts below demonstrate, these are undisputed, that the city council enacted the legislation in, I think it's the end of January 2020. The city sent a letter to Extraction informing Extraction that this new legislation had happened and that, you know, there's a variety of ways in which it could comply with the statute. And it also outlined the deadline if they were going to submit a noise study by which that had to occur. And the city waited for the expiration of that deadline, cited them for the failure to submit the noise study after the ordinance had been enacted. So this isn't it. They're not being penalized. Extraction is being penalized for conduct that has already occurred. It was for the new conduct after the enactment of the ordinance. And so that's why ex post facto doesn't apply here. I mean, it's kind of like, well, I was thinking of this, that I agree that Extraction is in the position it's in terms of being an industrial use by virtue of its prior approval. But that doesn't mean it's being punished for its conduct by being an industrial user. It's being punished for not providing the noise study that was required of it after the enactment of the law. I was thinking of a good analogy. It's kind of like, Your Honor, the most recent Senate Bill 217 is the police officer. It's some of the new provisions that are put on police officers now. One of the provisions of Senate Bill 217 that was enacted last year is that police officers now can be convicted for failing to intervene, right, in a use of force provision, in a use of force situation. Well, that didn't exist before, and no one would think of saying that law is ex post facto merely because police officers got their peace officer certifications prior to the enactment of Senate Bill 217. Now you look at the conduct they're engaging in. And if it was after the enactment of 217, they failed to intervene, you know, it's not an ex post facto application of the law. This is the same thing. So, Your Honor, I think I am pretty darn close to my, I don't know what your stopwatch says.
You got 1625 now.
Oh, my Lord. Do you have any questions for me that I have not answered?
Well, I thought I did remember seeing some reference in Extraction's brief about taking, regulatory taking.
Yeah, you know, Your Honor, there's a mention to it. There's no such thing that a regulatory taking is an offense to a criminal, to a criminal charge. Right? I mean, if something is a taking under our Constitution, Article 2, Section 25, the person who claims the taking is entitled to just compensation. Right? It's not, there's nothing in that provision that says it's a shield against criminal activity or police powers or anything to that effect. Right? Because sometimes governments act within their police powers, go too far, create a confiscatory situation, and compensation. So it has nothing to do with this case. You know, Extraction has other, you know, there are other forums available to Extraction to pursue that theory. And I think at times they mention in the briefs that they're doing those things, but I don't think there's any expectation for this court to get into that issue for purposes of a municipal court prosecution. And I'll say, and I'm not going to go, to me it's more of interest. If they're really pursuing it, I'm happy to address that in some supplemental briefing. We never got the impression that it was a preserved and articulated defense to the prosecution.
Thank you, Mr. Mark.
Can I have one moment?
Sure.
Since I do have a little extra time. Your Honor, there is just one thing that I wanted to point out. We referred to this in our briefing too, when we talk about the definitional section, that, you know, the first sentence, the first sentence can be read also to include extraction, because the first sentence talks about the kinds of uses that would be required for special review in the I2 and I3 zoning area as a definition of industrial use. So we set this out in our brief too, that we believe that sentence, even though extraction isn't operating under a special review permit, the first sentence can be read to, and reasonably read to be a description of the same kinds of uses that are required, right, for special review in those zoning districts, which include oil and gas, are the ones captured by the definition of industrial use. So, and then we set this out in the brief. So we think extraction is captured by both the first and the second sentences of the definition.
Before you begin, Mr. Phil, I need to take a few-minute break.
Sure.
we're back on the record in 20CV30381, City and County of Broomfield versus extraction on gas. And extraction has reserved 1936 for its rebuttal. Let's kind of focus our discussion a little bit. Mr. Cowan, okay? Let's talk about the test, legal test for retrospectivity. And I'm just going to cite for everyone, Taylor Morrison versus Bemis Construction, 411P3D72. And that is Colorado Court of Appeals decision from 2014. And I guess the only reason I have an affinity to it is the trial judge was my former office mate judge, Scott Crabtree. So, but I'm going to quote at length from the opinion, and then we're going to have a focused discussion. And the Taylor Morrison court observed, legislation is applied prospectively when it operates on transactions that occur after its effective date, and retroactively when it operates on transactions that have already occurred for rights and obligations that existed before its effective date. And then we know there's a presumption of prospective, however, they can reserve the General Assembly. And they go on to say our Constitution prohibits the General Assembly from passing laws that are retrospective in their operation, citing Article 2, Section 11. The law is unconstitutionally retrospective if it takes away or impairs vested rights acquired under existing laws, or creates a new obligation, imposes a new duty, or attaches a new disability in respect to transactions or considerations already passed. The retroactive application of the statute is not in and of itself unconstitutional. Thus, when a statute affects a change that is not substantive, but, for example, is procedural or remedial, in nature, the retroactive application of the statute does not violate the constitutional prohibition against retrospective legislation. Statutory change is substantive when it creates, eliminates, or modifies vested rights or liabilities. Right is vested only when the right to assert it does not depend on the common law or the statute under which it was acquired, but rather has an independent existence. And then it goes on to quote the Umbermite case. A vested right must be something more than a mere expectation based upon an anticipated continuance of the existing law. It must have become a title, legal or equitable, to the present or future enjoyment of property, or to the present or future enjoyment of the demand, or a legal exemption from a demand made by another. Thus, a vested right must be a contract. And I'm not starting your clock because you're not talking. You're not talking. Thus, a vested right must be a contract right, a property right, or a right arising from a transaction in the nature of a contract that has become perfected to the degree that it is not dependent on the continued existence of a statute or common law. In determining whether a right is vested, courts consider 1, whether the public interest is advanced or retarded, 2, whether the statute at issue gives effect to or defeats the bona fide intention or reasonable expectations of the affected party, and 3, whether the statute surprises those who have relied on contrary law. Determination that retroactive application of a law impairs a vested right, however, is not necessarily dispositive of the retrospectivity inquiry, because such a finding may be balanced against public health and safety concerns, the state police powers to regulate certain practices, and other public policy considerations. Retroactive application of a law that implicates a vested right is only permissible if the law bears a rational relationship to a legitimate government interest. That was a lot, but that is an encapsulation of the retrospectivity analysis. So, in light of Taylor Morrison, how does extraction fall within all of
I will endeavor to explain, and fortunately, I reread Taylor Morrison recently. So, we begin by noting that the Taylor Morrison case uses the same definition of retrospective laws that the Colorado Supreme Court has used for over a century, stemming back to that 1814 Justice Story case. A law is retroactive if it takes away or impairs vested rights acquired under existing laws. The facts of Taylor Morrison found that it was a subcontractor, the soils subcontractor had negotiated a limitation of liability. And the court went through the retrospectivity analysis from that soil subcontract perspective. It thought that it had a right to limit its liability under existing law. It was surprised when the legislature changed the law to render all such limitations of liability in residential construction contracts void. And that is why the court held that the soil subcontractor, or that the Homeowner Protection Act, that law that voided such limitations of liability, was retrospective in operation as to the soil subcontractor. And so we begin by submitting that extraction is in the same position. If you consider the factors, and by the way, I think as we discussed earlier, the fact that extraction's rights are vested are not in dispute here, but that is confirmed when you look at the factors discussed by Taylor Morrison. We acknowledge that Broomfield has got a public health, safety, and welfare concern here. The balance against that is extraction's expectation. It had a deal. The limit that would have applied under state law, the noise limit, was 75 dBA. That's the COGCC's rule that would have applied if there had been no operating agreement. It would have applied under state law and under the existing Broomfield Municipal Code at the time. Because remember, there's a separate chapter that governs oil and gas, which I will address when we get to the specificity specific to fields of general. That would have been the operative noise limit, 75 dBA night noise. Broomfield and extraction had an opportunity for a win-win here because extraction could make its operations quieter through application of the state-of-the-art technologies and sound walls and quiet frac fleets and using not diesel generators here. Those are noisy. Extraction used grid electricity. Extraction did all kinds of things at substantial expense to lower its noise levels and get them down to under, at this site, under 65 dBA, or always within ambient +4. So when Broomfield came along with the night noise ordinance that says 65 dBA, ambient was not good enough, 40, even though ambient noise is over 40 in this location, which I'll address when we get to impossibility. But that noise ordinance certainly surprised extraction and an expectation that this was our deal. It invested money to enable it to operate pursuant to the deal of ambient +4, and then it gets the regulatory rug pulled out from under it with the noise out ordinance. That is precisely the scenario that retrospectivity, the constitutional prohibition against retrospectivity is designed to protect against. So extraction is analogous to the soil subcontractor in Taylor Morrison. Now, to further address the language in Taylor Morrison, which acknowledges that even if you've got a retrospective law that applies civilly, it's still subject to some kind of balancing as against the police power. Taylor Morrison does say that, and we can't disagree with it. However, this is not civil enforcement. This is criminal enforcement. And as Mr. Marks pointed out when he was addressing retrospectivity, he argued that the only aspect of Article 2, Section 11, prohibiting ex post facto laws that applies here is the ex post facto prohibition. Fine, this is criminal. And all of this analysis, it's basically retrospectivity in a criminal context equals ex post facto. There are very few Colorado cases addressing ex post facto in this kind of situation, but it applies here because Broomfield, the noise ordinance is a criminal prohibition. Now, We'll start here then. I want to address retrospective.
Well, let's stop there. So your argument that it's ex post facto, because now
It's a retrospective.
it's now acting upon in an adverse manner, something that prior thereto was legal, okay?
It was, exactly. Extraction had a vested right to operate at ambient +4. It was established. The whole vested rights part of the analysis is not in dispute. And then Broomfield comes along and says, you may have had that vested right, but not anymore. We're changing the rules. Now you got to operate at no louder than 40. And yes, so the noise ordinance does exactly what it may not do. It takes away or impairs vested rights acquired under existing laws. Remember, the operator agreement is a contract, and it's more. It is a resolution of the Broomfield City Council. This isn't some ordinary contract by a low-level government employee. This was negotiated for years, studied for years. It came to a head at a hotly disputed city council meeting where lots of people spoke. And around 1 in the morning, they finally took the vote, and the Broomfield City Council in October of 2017 voted to approve the operator. It's an act of the city council which exercises all of Broomfield's legislative and executive powers. So I want to distinguish Van Sickle because the Van Sickle case is the one that Broomfield is now relying on, even though they only give it a brief mention of the briefs. That was the building code case where Mr. Van Sickle buys the building in Boulder. It's very different for a number of reasons. For one thing, it involves building codes. When you buy property, the property is permanent, or at least you hold it very long term. And that is why the rule regarding retrospectivity regarding building codes is that you got to keep your property up to code. That is why the court rejected Van Sickle's argument that the building code in existence at the time I bought the property is the only building code that can apply to me. No, because these are homes. It's the way building codes operate. Oil and gas is a completely different animal. Oil and gas installations are temporary. The operators get in, they develop the minerals, they drill the wells, get the oil and gas out, and they get out. They want to do it safely, but efficiently, but then they're gone after a relatively short period of time. The oil and gas, the well may be producing here, extraction wells, once they are drilled and hydraulically fractured, once they are producing quietly the pipeline, which incidentally, Your Honor, is why there have been no more noise complaints from the Livingston site once the drilling and the completions phase was done. That's when the noise complaints occurred, and it was for a brief period of time, roughly 2 months, but that is done. Extraction is now producing quietly the pipelines, and the noise complaints have stopped. To take Van Sickle and try and apply its analysis here, this situation would require, and when we go through this in the briefs, you would have to add a lot of hypotheticals. Imagine if Mr. Van Sickle said, I'm considering buying a property in Boulder, but I don't want to have to keep it up to code. And what's more, I'm only gonna be using this property that I'm gonna buy for a couple of years, and then I'm going to demolish and build something new. So Boulder commissioners or Boulder City Council, how about we make a deal that if I buy the property, I don't have to keep it up to code for the few years that I'm gonna own it before I demolish and build something new. And the city council or county commissioners expressly say, yes, deal, signed. That would be Van Sickle transported to our situation or made analogous to our situation. And under those circumstances, Van Sickle would have won the case. The general rule of not having to keep your building up, or having to keep your building up to code wouldn't apply where the executive power of the county or the city says, all right, we'll make a deal regarding this property under these circumstances. So that is why the Van Sickle case, which I'll acknowledge is probably the best case that Broomfield has to offer, is still not good enough to challenge the retrospectivity analysis. This law is retrospective as to extraction. And it definitely applies here. There's no fallback position because it's a criminal law. Ex post facto prohibitions against retrospective laws are flat prohibitions. And again, once again, this doesn't come up very often, so there aren't existing cases, but you've got to imagine the Eason case. If instead of Boulder County Commissioners saying, take your trailers and go, they had simply enacted an ordinance making it illegal to have a storage business using semi-trailers and punished criminally. That would be classic ex post facto, which is why Boulder didn't do that and why Broomfield cannot do it here, should not have done it with this noise ordinance. I'd like to briefly, Your Honor, just go through our 12 arguments. And I'll try and keep, how much time do I have? 8 minutes, let's do it. First argument, the future regulation. The municipal court did find, and this is one thing where the municipal court was absolutely correct, but found that in order for the noise ordinance to apply to extraction, it had to be a valid future regulation. Broomfield has not cross-appealed that determination. And Broomfield has not made any specific arguments contrary to the pretty fairly obvious fact that the noise ordinance is not generally applicable. It is not applicable to all commercial operations and all industrial operations. We've set forth it only applies to certain defined industrial operations without roofs. That's the antithesis of a genuine future regulation. Broomfield made some arguments in its brief about, oh, well, we repealed and reenacted the entire code as we have set forth in the briefs. Those are not, those arguments lack merit, let me put it that way. The old ordinance parts of the noise code do not become new in future regulation by virtue of being repealed and reenacted. And I did not hear Mr. Marks offer any further defense of that. That's reason number one to reverse. Reason number two is Broomfield's chosen definition. The court did focus on this. Broomfield argues that the word includes in the definition is not illustrative. It's an additional set of things that are defined. Your Honor, we submit that that's contrary to the natural way of interpreting legislative language. Statutes are commonly defined categories and then state the category includes, and we'll often say, but is not limited to the following elements. And all of those elements are examples of things, not exclusive, but examples of the defined category. That is the natural way to read Broomfield's definition, 936.010 sub F. Broomfield's argument that, no,
So they should have wrote it. I mean,
yeah, they could have written it.
industrial use means any industrial use that must be permitted as a use by special review in an I2 or I3 zone district and includes. Wouldn't that be a better grammatical way?
And includes, that would be better. It wouldn't be as good as industrial use also includes.
Okay.
That would be the natural way to say, in addition to the defined category, there are a bunch of extra things that are defined as industrial use. That would be the best way, and that is eminently not the way language Broomfield chose. Under these circumstances, especially here, I should point out, Your Honor, where there is a separate portion of the Broomfield Municipal Code, that's Title 17, Chapter 54, is a portion of the zoning code addressing oil and gas operations. That code has specific noise provisions that control oil and gas, which is part of our special prevails over general argument. Whereas here, there's a specific portion of the code that addresses noise in oil and gas operations. You've got to be all the more specific if you want. In fact, the only way to do this properly, we submit, would be to amend the oil and gas chapter as well as the noise chapter, since the oil and gas chapter is more specific than the noise chapter, but that's specific over general. At the very least, Your Honor, there is ambiguity here. And the court acknowledged, the trial court acknowledged that this language was ambiguous. It could be interpreted both ways. The rule of lenity does apply, as the court observed. The trial court's construction that the fact that extraction of Broomfield expressly intended for this to apply to extraction by virtue of the preamble, that only goes to show targeting. Physical impossibility. The court is right that this is an affirmative defense. It was Broomfield's burden to disprove the offense. Extractions witnesses testify that it's quite simply impossible to operate below ambient. That shifted the burden of proof. Broomfield has argued that, well, you could have done a noise modeling study. Didn't argue that until this appeal. They didn't argue that in the trial court, and we presented authority to the court that while a prosecution, as you know, that they won below so they can defend on alternative bases, that's true, but the bases have to be supported by the record. And the prosecution cannot win below, realize that, oh, its case is fundamentally flawed, and then offer a whole new case on appeal, a whole new theory of its case. We have authority in our review. The Colorado Court of Appeals rejected that. If you don't even mention it below, provide no evidence, there's no notice to the defendant that this is the case you've got to defend against. You can't defend by presenting a new case on appeal, which is what the extraction is trying to do. Broomfield is trying to do. Broomfield also argues that, oh, you can comply, it's not physically impossible, you can comply by shutting down. Not so, Your Honor. We made a record that extraction cannot shut down. Yes, cannot shut down at night. How's my time? A minute. Okay. We made a record. It's in our offer of proof that extraction cannot shut down. And we made that offer of proof. The municipal court gave Broomfield anything you want to object to here, anything you want to challenge. Broomfield did not challenge extraction's offer of proof, which was supplemented by actual testimony from its witnesses that shutting down at night is not possible, it's not safe. That's not an answer. Your Honor, I'm not going to have time to go through all points as a summation. I'm going to jump to the conclusion, but everything has been covered here. We've given the court 12 arguments, any one of them. If the court finds that any one of these 12 arguments has merit, it must reverse. Now, it was mentioned that there are other cases. There's a federal case that raises the regulatory takings question. Extraction isn't looking for litigation. It does not want to have to pursue its Section 1983 claims against Broomfield or assert a takings claim, which incidentally is a fallback position. If for any reason this gets upheld, then it is confiscatory taking, but that's not this court's concern.
No, regardless of what I do, this is going downtown, so
Yeah.
it's okay.
But the point is, Your Honor, extraction isn't here to litigate. Extraction is here to develop the assets that it acquired safely and efficiently and finish that development and go. Extraction made a deal with Broomfield. It was a win-win deal. Extraction reasonably relied on that deal. Broomfield cannot now. It's bound because here in Colorado, cities are bound by their contracts. It can't pull out the regulatory rug the way it is trying to do. We urge the court, even though the court can affirm on any one basis and can choose to do this narrowly, we urge the court to issue a broad opinion because we might otherwise be back here. I take it that that's okay. We urge the court, whether, however it chooses to do it, to issue as broad an opinion as possible. As we've said, we try to explain these constitutional and statutory facts of life to Broomfield, but it doesn't get through when it's extraction trying to explain. Broomfield needs to hear it from the court. We ask the court, therefore, to reverse these convictions, and then the other location will follow.
So you want me to reverse remand with the directions to the municipal court judge to dismiss the criminal prosecutions, right?
Yeah, well, reverse, yes. And yeah, they should have been dismissed.
And
that's correct.
That's why you're asking for a broad opinion. And dismiss because of
Yes.
A, B, C.
exactly right.
Okay, again, I know whenever I do, I get appealed, so that's fine.
Well, but by the way, Your Honor, in terms of appeal, remember, you're sitting in the public capacity.
Right.
Certiorari only.
Right, I know, it goes to the Springs.
That's right.
All right, thank you, everyone.
Thank you, Your Honor.